Hello, Stone and Hunt sections, and welcome to the wild and wonderful world of civil discovery. Many, if not most, civil litigators spend the vast majority of their time doing discovery. So it's a very, very important topic. And let's talk about why discovery is so important first. Well, discovery allows you to use the resources of the court to find out information you need to know to build your case. That's huge, right? And that serves some additional functions. Once you find out additional information and everybody has a pretty good sense of what the facts are, that facilitates a much more meaningful settlement discussion. And if settlement doesn't work out, perhaps summary judgment is a device that can be used to dispose of the case. Because if it turns out after discovery that there's no real dispute about what the facts are, then the judge can decide the case as a matter of law, and that saves the time and expense that would be entailed in having a full-scale trial and impaneling a jury. So, discovery, important. So remember when we talked about the 12b6 motion and how it's the goal of plaintiffs to get to discovery, and it's the goal of many defendants to keep plaintiffs from getting to discovery. So let's assume that plaintiffs have survived a 12b6 motion for failure to state a claim, which means that they've unlocked the door to discovery. So what lies behind this door that hides the riches and treasures? What's the mysterious thing behind there? Well, there you go. It's our good old federal rules of civil procedure. So the good news is that the federal rules contain pretty much everything you need to know about discovery. The bad news is they're sometimes kind of hard to parse through. So the goal of our presentation here today is to give you an overview of the way the federal rules are set up on discovery, and to give you a sense of where you might look for specific questions that you have about a specific way of getting discovery done. Okay. So as we proceed, always remember, our system is adversarial. It means each side should and must do its own work. So the idea is that our system is set up so that each self-interested party presents their side of the story and amasses evidence that supports their side of the story. And from that clash of the different versions, the truth emerges like a butterfly, and we get to a just result. So to make it work, each side has to do its own preparation without concern that the other side might pilfer their work. Right. But on the other hand, the whole point is to get to the truth, right? We want a just outcome. And hiding things from the other side does not necessarily get you to a just and truthful answer. In fact, you might think that getting your cards out on the table would be a better way, where everybody knows what the facts are, everybody knows what everybody else knows, and we can figure out the just outcome. So those days, those good old bad old days of the classic Perry Mason episode, where the surprise witness shows up at the very last minute, or they unearth a piece of evidence nobody knew about on the third day of trial, the smoking gun, right? Those days are pretty much gone, at least in federal court, because the sense is that we do a better job of getting to the truth. We get a higher quality of justice if we have our cards out on the table. Now, it might strike you, and rightly so, that there's a tension between these two policies. On the one hand, each side does its own work without concern that it will be pilfered by the other side, and on the other hand, getting all the cards out on the table. In fact, as you can see, the federal rules are basically a balance of those two policy concerns. On the one hand, we want to get to the truth, which requires that we put all the cards out on the table, everybody knows what the facts are, and we can go from there. On the other hand, we still are in an adversarial system and we want each side to do its own work. So you'll see as we go through the rules on discovery that they're basically a balance between these two concerns. It's particularly obvious when you look at the rules on work product, for example, which we'll talk about shortly, and on expert witnesses as well. But these policies basically underlie all the discovery rules. Okay, so let's talk about what methods you can use to discover information from the other side. There are 5 methods of discovery recognized by the federal rules, and here's what they are. First of all, depositions. This is probably somewhat familiar to you. So a deposition is an event where testimony is taken of a witness who might be a party or who might not be a party. Both sides are there to take the testimony to examine and then cross-examine. There's typically a court reporter there to take the information, to record the information, and to swear the witness. This is sworn testimony. There's not a judge there, however. Okay, so depositions can be used against both parties and non-parties. Interrogatories. It's just a fancy word for questions. And you can ask questions of other parties. You cannot ask questions of non-party witnesses. This is a method of discovery usable only against other parties. But you can pose questions, and and you do it in writing, and they have time to respond in writing. So these can be a little more thoughtful because you can plan out the way you word your questions, and then on the other side they can plan out the way that they answer those questions. Requests for production. Just like it sounds, these are requests that the other parties produce documents and other tangible things that they might have within their possession that you think would help build the case. Physical and mental exams. Yes, that's right. The federal rules allow you to, under certain circumstances, have a physical or mental exam performed on another party in the case or somebody within that party's custody. And then request for admissions is the 5th type of discovery. And that's almost more like a pleading than a discovery device. That is to say, this typically comes at the end of the discovery period, and the idea is that once we have an idea of what the evidence is and what the facts are going to be, then if we can get the other side to admit that certain facts are true, then we can take those facts off the table and not waste any more time litigating about them. Okay. So I'd like to give you an idea about how the discovery rules work. They're captured in the Federal Rules of Civil Procedure, numbers 26 through 37, and you're going to see that 26 is by far the most important of these rules because it really provides the overarching themes, the tests that pervade all the rest of the rules. So let me just walk you through these rules so that you have a sense of what is where, so that as you're going through problems and working through any other kind of discovery that you might have to do, both for this class and in your internships and elsewhere, you'll know basically where to look when you're looking up a specific discovery question. Okay, so starting with Rule 26. Rule 26 is your blueprint for discovery. It's full of information that you will find super helpful. And for that reason, we're going to break it down in some detail here shortly. Rules 27 through 32 are about depositions. And there's a lot of different information in those rules, but the most important probably to know about are Rules 30, which explains how to make a deposition happen, how to set it up, how that works. And then Rule 32 explains how depositions may be used. Now let me just stop for a second and talk about that. In our system, we have a very strong preference for live testimony. The idea being that we want the fact finder, whether that's a judge or a jury, to actually see the witness testify live so that they can decide how credible that witness might be. You can't do that if you're just looking at a piece of paper, right, that captures a conversation. So typically we don't allow depositions to be introduced into evidence, but Rule 32 explains how depositions may actually be used for different purposes at trial. Okay. I also have a note here that you should, in addition to the rules 26 through 37, keep in mind Rule 45, the subpoena rule. So remember that we said depositions can be taken both of parties and also of non-party witnesses that you might be interested in deposing. And so think about this for a second. If somebody is not just cooperating, doesn't necessarily want to go to a deposition and be deposed, well, if they're a party, they're already subject to the power of the court, right? They have to cooperate. But if you're a non-party, what is there to make you cooperate? Enter Rule 45. Rule 45 allows you to get a subpoena to compel a non-party witness who's not otherwise cooperative to come to a deposition and to talk to you in the deposition. So when you look at Rule 45, it will explain how geographically where the subpoena has to issue from and how to make that work. You can also use a subpoena to ask the non-party witness to produce things that they might have in their possession, including documents. And so that's a really helpful tool when you're trying to get to non-party witnesses. Rule 33 explains how interrogatories work. Remember, interrogatories are these questions that you pose to other parties. There's a limit there and how many you can use because there was a concern that these were kind of getting out of hand. There were too many of them. And in fact, some of the proposed amendments to the rules that are currently under consideration are an effort to limit that even further. Rule 34 is a request for production. Again, that describes how you can ask that things that are within the other party's possession might be produced. That includes documents and other tangible things. And again, Rule 34 in conjunction with Rule 45 allows you to get things and documents that non-party witnesses have as well. Rule 35 allows you to get physical and mental exams of another party or somebody within their custody. Yes, really. Think about that for a second. You're using the power of the government to force somebody to be examined by a doctor or a shrink, right? And that's kind of a big deal. So there are extra requirements in Rule 35 to make that happen, and we'll talk about those shortly. Rule 36 describes the process for making requests for admissions. As I mentioned earlier, these are almost more like pleadings. If you can get the other side to admit that the fact is true, you can take it off the table. It becomes a stipulated fact and becomes true for the purposes of this case. And then finally, Rule 37 is a sanctions rule. That is, it's a rule that is designed to enforce all the other discovery rules. So if you have someone who's not cooperating with discovery, Rule 37 tells you what to do about that. You can think of Rule 37 as sort of a enforcement mechanism like Rule 11 is, and it works in conjunction with Rule 26G, which requires that every discovery request and discovery response be signed. Okay, so let's take the important ones of these and break them down even further. Start with Rule 26, the blueprint for discovery. Rule 26 is chock full of great information. Rule 26 is your best friend when you're engaging in discovery because it tells you all kinds of information that you need to know. So let's break it down and talk about the different parts of Rule 26. It's a very long rule, as you know. 26A requires that some information be disclosed automatically, and it's mandatory that it be disclosed automatically. This, by the way, is a relatively recent innovation. The traditional model is I don't have to tell you anything till you ask for it. But it became clear that certain types of information were so important in terms of that policy of getting all the cards out on the table that in every case we should just disclose that information at the outset and not wait for a request to come. Okay. 26B1 tells you the scope of discovery. That is, if it's not going to be disclosed as an automatic matter under Rule 26A, what information can we use those 5 discovery devices to find out? 26B2 talks about limits on discovery. There's this concern that discovery is by far the most expensive part of litigation, and sometimes the expense of it far exceeds its value. So the idea is to have a proportionality there. And again, the proposed amendments are looking to make that even more stringent. 26B3 is the work product privilege, which is designed to promote that first policy we talked about, the adversarial one, by protecting the work of lawyers and their agents from discovery by the other side in some circumstances. So each of these provisions we're going to break down in more detail shortly. 26B4 contains specific rules about expert witnesses, who are a special kind of work product, right? You engage experts to help build your case, and then the question becomes, what is the other side entitled to find out about your experts? 26C allows the court to enter orders protecting information that gets produced for or during discovery, and sometimes preventing information from being produced during discovery. 26D and F describe the timing and sequence of discovery, and then how discovery plans come together. 26E creates a duty to supplement discovery disclosures. So if you have answered an interrogatory and at the time you answered it, you complied with your obligation to be fully truthful, but it becomes clear later that there's something you left out, 26E creates an affirmative duty to supplement your previous disclosure. Okay, so 26G, here we go, this is a big one. 26G requires that you sign discovery documents. So this is essentially a special Rule 11 for discovery. Remember we mentioned a bit ago that Rule 37 is a sanctions or an enforcement mechanism, and it works in conjunction then with Rule 26G to make sure people don't abuse the discovery process. Okay, wow, so as you can see there's lots and lots of information packed into Rule 26, so we need to break it down and talk about the key provisions in more detail. So let's do that now, starting with Rule 26A. So 26A says, a party must, without awaiting a discovery request, provide to the other parties the following information that the disclosing party may use to support its claims or defenses. So you can see that I've highlighted some key words here. A party must, that makes it mandatory, right? You don't have any choice about this. Provide to the other parties information that you, the disclosing party, may use to support your claims or defenses. And the information you have to disclose includes fact witnesses, that is, witnesses to the events, their identity, their contact information, and the subject matter that they would testify to, that they know about. You also would have to disclose copies or descriptions of documents, electronically stored information, known by the acronym ESI, and other tangible things, and the way you're computing damages, and what insurance policies may cover the claim involved. There's also some special disclosures that Rule 26A requires you to make with regard to experts. That works in conjunction with another rule, so more on that to come. We'll get there shortly. Okay, let's go back up to that top sentence there. A party must provide to the other parties, the other side, information the disclosing party may use to support its claims or defenses. In other words, you're required to turn over the information that's good for you, that supports your case. And by the same token, your opponent is required to provide to you the information that supports their case. But what do you really want to know? What you really want to know, well, you do want to know that, right? Because you have to prepare to meet that information. But what you really want to know is what information the other side has that would help your case. And notice that 26A doesn't make them turn that over to you, and it doesn't make you turn over to the other side information you might have that would help their case. That's why we need the discovery devices, those 5 devices I described earlier, so that you can find out information the other side has that would help you. Okay, now let's go to 26. 26B1 describes the scope of discovery. That is, the scope of the information you can use those 5 discovery devices to get from the other side, beyond what they've been required to reveal to you automatically under 26A. And here we go. What kinds of information can we find out through using discovery? There's a 3-part test. Here it is. You can find out any non-privileged matter, and one of the privileges we're going to talk about is the work product privilege, but there are others, attorney-client privilege and so on. So any non-privileged matter relevant to any party's claim or defense that would be either admissible at trial or reasonably calculated to lead to admissible evidence. All 3 of these things must be true for the information to be discoverable. Now look at that relevant standard. It has to be relevant to any party's claim or defense. So how is that different than the Rule 26A standard about what has to be automatically disclosed? Think about it. You have to automatically disclose information that's good for you, but you're allowed to use the discovery devices to find out information relevant to any party's claim or defense, right? So this is how you find out if the other side has information, that's good for you. Okay. 26B1 goes on to say, for good cause, the court may order discovery of any matter relevant to the subject matter involved in the action. That's much broader, right? And in fact, that was the old relevant standard until relatively recently. And there was a concern that it was too broad and that people were using federal civil litigation to go on these fishing expeditions, right? That they would just go file cases in order to get discovery and find out all kinds of, inside dope about the subject matter involved, and it wasn't really relevant to claims or defenses. So the relevant standard was tightened up. But as a compromise, they left in this phrase that I have there in the note that allows the court to, if necessary, for good cause shown, order discovery on a broader scale. But when it says the court may order, as you know, when you see that word may, it means the court has discretion about it. One of the goals of the proposed amendments, you guys remember going over the courthouse the first week of class and listening to debates about the proposed amendments to the federal rules, one of them would change this test and tighten that standard even more. So we'll see if that passes. I think the current groundswell is against passage, but we'll see. For now, this is the state of the law. All right. Let's talk about the work product doctrine under 26b(3). I love this picture of this poor lawyer who seems to be overwhelmed by paper there. And here's the deal. If you're that poor lawyer overwhelmed by paper and all this work you've done, wouldn't it really tick you off if you amassed all this great evidence and the other side just sat back, sideline sitter, just watching, and then served a discovery request and pilfered everything that you'd worked so hard to assemble? Right? That would be really annoying. So the work product doctrine is meant to protect you from that and make the other side do its own work. Right? If you're going to work hard, they should work hard. It's their job to assemble their case. That's kind of the idea. So how does it work? It says in 26b(3), a party may not discover documents and tangible things prepared in anticipation of litigation or for trial by or for another party or its agent. So, in order to trigger work product protection, it has to be information captured in a document or another tangible thing prepared in anticipation of litigation or for trial. If it exists separately from that, then they're fully entitled to get it, right? Because they're not pilfering your work. But if you've prepared it for your case, then the idea is they should go off and do their own work and not pilfer yours. Okay. Here's the deal, though. This privilege is conditional. That is to say, it can be overcome. So if the requesting party can show two things, it can get access to the information you've prepared in anticipation of litigation, even though it's your work product. Here's the two things they'd have to show. They'd have to show that they substantially need the material to prepare their case, and that they cannot, without undue hardship, get the substantial equivalent by other means. So you can see here in this rule a real balance between those policies that I mentioned at the outset. On the one hand, do your own work, right? Assemble your own case. And that protects the adversary system. But on the other hand, if it's not possible for you to get access to the information, there's no other way to do it without undue hardship, because you can't get the substantial equivalent on your own, and you really need it. You have a substantial need for it. Okay, well then the getting all the cards out on the table policy trumps. So that's the delicate balance in 26b(3). Here's something, though, that's kind of cool. The rule goes on to say that even if a party can overcome the privilege by making the showing that they substantially need the material and they can't get it on their own, the court still must protect against disclosing to the other side the mental impressions, conclusions, opinions, or legal theories of their opponent. This makes total sense if you think about it. In an adversary system, the idea again is that each side prepares their own case and brings it. They bring their A game to court, and from the clash of the two sides, the truth emerges. Well, if you were preparing your case and you were worried that every time you wrote down a strategy, a legal theory, an impression, maybe you're writing down, oh, that witness seems really credible, or, ooh, that witness doesn't seem credible at all. If you knew the other side was going to get access to what you wrote down, what would you do? Well, my guess is you wouldn't write it down. And you wouldn't do nearly as good a job preparing. So we want to encourage lawyers to do the best they can in preparing their case for their client, And in order to protect that and to protect that incentive, we have an absolute protection against disclosing strategies, mental impressions, conclusions, legal theories to the other side. Okay. 26b3 also includes kind of a weird little loophole. And here's what it is. Anyone who's previously given a statement to a lawyer or a lawyer's agent in anticipation of litigation is entitled to get a copy of their own previous statement. So if I talk to a lawyer and the lawyer took down my statement pretty close to verbatim, I'm entitled to get a copy to see what they wrote down I said. So just kind of keep that in the back of your mind, and we'll play with that on Monday with our problems. Let's talk about expert witnesses. Experts have become quite an important aspect of the way cases get litigated these days, particularly things like products liability cases where causation can be quite a difficult issue. And if you think about it, when you're preparing your case and you're deciding what expert to hire, so let's just think about that for a second. So let's say, I'm shopping around for an expert, and I call up Dr. Jones. And Dr. Jones says, after I describe my facts and so on, says something I really don't like. So maybe I don't hire Dr. Jones, but man, do I want the other side to know about Dr. Jones? Because if Dr. Jones says something I don't like, then chances are he says something that they really like, right? So what I'm trying to say is that shopping around for expert witnesses is your work product, right? That's your work in putting together a case. Okay, but let's change it a little bit. Let's say Dr. Jones is brilliant, and I really want her to testify for me at trial. Should the other side in that situation have access to Dr. Jones? Absolutely, because they're going to need to depose Dr. Jones in advance of trial and prepare to meet her testimony. So the rules on expert witnesses, which are divided into two parts of Rule 26, A2 and B4, are really about dividing expert witnesses into two categories. That is, experts may be presented at trial who ought to be made known to the other side, right? If you're going to use an expert at trial, the other side has a right to know about it. They have a right to know about the expert's qualifications and credentials and what the expert is going to say, and they're probably going to want to depose that expert. Fair enough. But if it's an expert employed or consulted only for trial preparation, that's just your work product, and the other side can go find their own expert, right? You don't have to do their work for them. Make them go find their own expert. So to the extent an expert is employed only for trial preparation or is just informally consulted in preparation for trial, the idea is that the other side does not need access to them. They can go find their own expert. So 26A2, remember that's the automatic mandatory disclosures, has particular rules about what information gets disclosed about experts who may be called at trial. And 26B4, then, the other side of the coin, protects information about experts employed only for trial preparation. And if you look at it, it says that the other side can find out about those experts only upon a showing of exceptional circumstances. Again, the idea being, the other side should go find their own expert. They don't need yours. We're going to protect yours unless they can show exceptional circumstances. Maybe this is the only person with expertise in the area, or maybe the document or thing they examined has been destroyed and they're the only one with information. They have to show some kind of exceptional circumstances. Okay, so those are experts. Okay, let's talk about protective orders And start with this really basic question. What can you do with the information you file out during discovery? Let's say maybe you're representing a client in a sexual harassment case against a high-profile government official or politician, and you, through discovery, get the politician to produce their journal where they record all kinds of crazy, racy stuff. What can you do with that information? Answer: anything you want. You can call up the New York Times, you can go on 60 Minutes, you can share the information with other potential litigants. Wow! Whoa there! Can the other side stop that? Yes. Enter the protective order. So, again, the default rule, the basic situation is you can do anything you want with the information you get during discovery, unless a protective order is in place. So how do you get a protective order under 26C? To do that, the disclosing party must show a number of things. They have to show, first of all, that they made a good faith attempt to resolve the dispute about the disclosure without involving the court, that they would be harmed by the disclosure, and that they have good cause for the protective order. They have to show all those things to get one. If they can do that, then the court, the rule talks about a number of things the court could do. The court could say the information doesn't have to be disclosed at all, or that it can be disclosed but then must be kept confidential and used only for the purposes of the case, that it can be disclosed only under seal, that the judge might redact certain information before they turn it over. There are all kinds of ways to proceed, and it's really within the court's discretion. One thing that's interesting and arguably problematic about this is that when you think about it, the court is an agent of government, of course, and by entering a protective order, the government, through the federal judge, is in some way, arguably, suppressing speech, right? Because they're saying information can't be shared. And for that reason, protective orders were challenged under the First Amendment. And in an interesting case called Seattle Times, the court says that a protective order entered on a good cause showing does not violate the First Amendment. So it's an interesting problem. What happens in a lot of complex litigation is that an umbrella protective order gets entered at the beginning of the case that requires that anything marked confidential during discovery, the parties agree that it won't be shared beyond the bounds of the case. But those are controversial too. All right, let's talk about everyone's favorite discovery device, physical and mental exams under Rule 35. Wow, this is kind of an amazing thing, that you can use the power of the federal government to force someone to undergo a physical or mental exam. How is that possible? Well, because this is considered more invasive than other forms of discovery, there are special rules to do it. Under Rule 35, you have to get a court order first, and the court has discretion about whether to grant it. And to get the court order, you have to show two things. You have to show that the person's condition, the party or the person in custody of the party, that person's condition is in controversy, and that you have good cause. The good cause inquiry is a balancing test. What are you balancing? Well, on the other hand, you're balancing the need for the information versus the intrusiveness of the requested examination that you're asking to have done. Okay, so putting a person's condition in controversy is a fairly easy condition to meet when you're talking about tort plaintiffs alleging personal injury, because by pleading that they've been injured, they have themselves put their condition in controversy. It's a little harder in situations when they haven't put their own condition in controversy. You'd have to have some kind of evidence of that. The balancing test is tricky, right? I mean, it depends. Do you, again, on how badly the information is needed on the one hand versus, well, what's this exam going to entail? Is it going to be very painful? Is it going to violate the personal space of the examinee? All those things go into the balance. All right, let's talk about sanctions in discovery. Okay, remember that Rule 37 is an enforcement mechanism that tells us what happens when people don't cooperate in discovery. So what happens if you serve a discovery request and the other side refuses to cooperate? What do you do? Well, the first step is to try to work it out, right? Judges, federal judges particularly, really don't like getting embroiled in discovery disputes. So to the extent that you can work it out without involving the judge, so much better. So that's definitely step one. Step two, though, if that doesn't work, is to move the court for an order to compel, which, just like it sounds, is a court order saying, hey, you have to respond to the discovery. So you make a motion to the court, ask for an order to compel. If the court issues the order to compel, then your opponent has to respond. But what if your opponent is really stubborn and still doesn't respond? Then what happens? Then you move for sanctions under Rule 37. Rule 37 lists the kinds of sanctions that the judge might impose. And most of them have to do with the idea that, you know, play fair or you're not going to get to play the game. So if you refuse to cooperate cooperate in discovery about particular facts, then the judge may well say, okay, we're going to take those facts as established against you. If you're not going to play fair where we can figure out what those facts are, then we're going to assume they're bad for you. And same idea here, that the disobedient party doesn't get to support or oppose a designated claim or defense because they haven't been forthcoming with the information about that claim or defense. So we might strike their pleadings that are relevant to that. Sometimes the court might say, we're just going to stop this until you obey the order, or in a very egregious circumstance might actually dismiss the case and or enter a default judgment against a defendant, or in really extreme circumstances might hold someone in contempt for failure to comply. But here's a little safety valve. Note that under the Rule 37, you cannot be held in contempt for failure to obey a Rule 35 order. Remember what Rule 35 was? Right, physical and mental exams. We're not going to throw you in jail because you refuse to obey an order to be examined by a doctor. Okay, so that's our quick down and dirty overview of the discovery process. On Monday, we'll be looking at some discovery problems using our Mrs. Puddleglum case and try to really get deeply into the rules and flip through and figure out how we get specific things done. So I hope this has helped give you an idea of some of the basics of discovery and that you will learn to keep calm and love discovery. Have a great weekend, everybody, and I'll see you all Monday.